Okay, we're going to move on to our next session. And so we are honored to have Mike Schmidt, who is the district attorney for Multnomah County, which covers Portland, Oregon. He took office at a really kind of quiet, calm time in 2020. And so he's going to share some of the things that he's been doing with the Justice Integrity Unit in his office, specifically with their resentencing and looking at excessive sentences. And then we also have Doyle Neiman. And so I think he's been around a bit longer working with the Prince George's County Attorney's Office. And he's going to also talk about his work with the Conviction and Sentence Integrity Unit, and especially focused on what they're doing with juveniles. So I'm going to pass it on to them.
Well, thank you, and thank you all for being here. As noted, my name's Doyle Neiman. I am from Prince George's County. Prince George's County, Maryland is a suburban urban county of 1 million people, the second highest crime rate in the state of Maryland, and a majority minority county with 80% minority population. So it's a bit unique in that context. I've been a prosecutor there for 25 years. During that time, I also served 6 years on our school board and 12 years in the legislature. So I've kind of come at it from a variety of points of view of policy, as well as being a practicing attorney. I'm now in charge, as noted, of the Conviction and Sentence Integrity Unit. It was created by our state's attorney, Aisha Brayboy, after she got elected in 2018. And if you'll pardon me a minute, I want to set a context a little bit for the discussion of reconsideration. And it start with the purposes of sentencing. This is sort of basic prosecution, but you know, I'm listed as R's, and I'll just focus on 3 of them for the moment. Retribution, which is punishment for a crime. So this is somebody who's been convicted of committing a crime. So not talking about the trial before, and they've been convicted. So retribution, recidivism, stopping them from committing another crime. Obviously, that happens while they're locked up, and that's part of the logic behind sentences. And also rehabilitation, because the goal, in theory and in practice, is to rehabilitate people, because the vast majority of people come back out of prison at some time or another and enter into civil society. So those are the 3 things. Now, when a sentence is done, a judge imposes a sentence, he freezes that balance. There's a balance between all those factors that a judge goes through when deciding on a sentence. It freezes that in a moment of time, and it stays that way, by and large. And the problem is that changes, that balance changes over time. So as conditions change, so attitudes change. The attitude about drug crimes has changed substantially from what it was at one point. And as people change, and as we learn more. So people change as they serve time in prison, especially long periods of time. And that's really what my focus has been, is long sentences. And we learn a little more. So the whole dynamic of what we've learned about youth development has fundamentally changed in the last 15 years or so. And that's reflected in a variety of Supreme Court decisions as well. But they have a scientific basis about brain development, that juveniles, their brains are still developing. And that gets translated into a variety of things, of lack of impulse control, lack of self-control, intense anger at times, all those things. If you've ever been a parent of a teenager, you should know very well. Its susceptibility to peer pressure and to community pressures, particularly of the negative kind. So that's where reconsideration comes in. Reconsideration is the ability to go back and look at that balance of factors between retribution, rehabilitation, recidivism, and say, is the sentence that was imposed still an appropriate sort of sentence? And let me talk a minute about what reconsideration is not. It is not about innocence, right? That's a different issue. That's wrongful convictions. It's not a post-conviction issue. It's not about whether the defense attorney asked the right questions or any of those sorts of issues. It's really not about the issues that come up on appeal, not about a retrial. Historically, there was a balance of forces between, in the history of the law, between law and equity. Law is a law, right? The things written down in statutes. Equity is a concept at the heart of the law, is historically developed in the Western society that was sort of to do what's just and right. A dispensation, not a right. And that's important to sort of understand. And we think about that is it is a matter of justice, but a dispensation that we're going to take a look here at what we're doing. So our work, as I said, is all about long sentences primarily. I think sometimes less, but mostly about long sentences, particularly focusing on young people. We started with juveniles because we have all these Supreme Court decisions that say life without parole is not an appropriate sentence for juveniles. So all of those folks who had a life without parole sentence and were juveniles at the time they committed the crime deserve a new sentence. But it kind of goes a little further than that. The Supreme Court has said, and that's been adopted in Maryland, and still is affirmed the rule of the law with the court, even in its new conservative format, to relook at the factors that go into sentencing. So they've kind of outlined the things. This is what we use for juveniles and also other defendants, a series of factors that should be considered. The nature of the crime. Now, frankly, we're going to treat the Montgomery County sniper who killed a whole bunch of people, who was a juvenile and whose case is still floating around in the Supreme Court, I think, a little bit differently than others. If it was a felony murder, that's a different situation. If they're an accomplice, that's a different situation. If it was an impulsive action, as opposed to a premeditated action, those are all factors that you look at. The nature of the crime, their role in it, right? Were they the active participant? Were they not? Felony murder, it means if you commit a crime, you're part of a group that commits a crime, you're responsible for all the crimes. Their age and their circumstances. How old were they? What was their family background? What were their circumstances that contributed to the crime? The reasons, if you will, for the crime and what's going on. Those are sort of the background issues. But then we also look particularly at the record in prison. Is there a evidence, tangible, concrete evidence that the individual has changed and are no longer the people they were who committed a crime, and thus less likely to commit crimes in the future? And age is obviously a factor of that in terms of the length of sentence. Evidence of rehabilitation. Those are things that we really look at when we evaluate that. And finally, it's kind of, if you will, reentry options. What happens if their sentence is changed? What happens if their sentence is released? And under what we do, we'll do both. We'll reduce a sentence, which may increase their eligibility for parole, or we'll modify it in a way that they ultimately will be released. Now, we believe strongly in our cases in reentry support. So we want people, if we're going to change a life sentence, for example, for somebody who committed murders, and that's the vast majority of the cases we've been dealing with, we want them to go into a structured reentry program. That's going to reintroduce them to society. They've been locked up for 20 years, 30 years, 40 years. The world is a very different place. We want them to be in an environment where they're going to have maximum opportunities for success. So those are the things that we looked at. In Maryland, we're fortunate that for juveniles, that we helped pass a law, the Juvenile Restoration Act, 2 years ago, and we played an active kind of role in crafting, developing that gives individuals who were juveniles at the time they committed the crime, who've been locked up for 20 years, the right to ask for a reconsideration and have a hearing on that. The law actually specifies all those things I just said, factors that the court must consider in ruling on on release. So was a major step forward to do that, not without controversy and not without the opposition of all but one other state's attorney's office in the state of Maryland, but which was Baltimore City. And Lauren Lipscomb is here from Baltimore City. You'll hear from her shortly. But it made a huge difference for a large portion of those folks who are in prison, and 60% of the individuals who would be covered come from our two jurisdictions. Now, that's where we are. Now, the practical side, however, is aside from the juveniles, there's a real serious issue because traditionally sentences are final, subject to appeal and post-conviction, all those legal things that could challenge a sentence, most of which are focused on the conviction, not on the sentence, right? There are very few mechanisms to challenge a sentence. There are more to say it's a wrongful conviction or an appeal, the trial was handled badly, it's a post-conviction, the defense attorney was incompetent. And so those deal with conviction, but there's really not many mechanisms for sentences. The Juvenile Restoration Act did that. So one is finding that mechanism. We've had some luck, and I will say that, frankly, this depends, well, reconsideration in general depends at least on a judge who is open-minded about it. But even more for some of the procedural things, we file motions to reopen post-conviction cases using the arguments of the Supreme Court, but kind of extending them to a larger group of people. That depends on sort of a sympathetic judge. Some are better than others, frankly, but and we don't have a clear process for that. And my associate here, Mr. Schmidt, is going to talk about one mechanism for that, which is kind of prosecutor-initiated reconsideration. And if you haven't already met, you may want to talk to May Lim. Raise your hand there. May Lim is with For the People, which is an organization that's been promoting that model of legislation across the state. We've been trying to do that in Maryland, but not successfully yet. So we'll count on that for the next legislative session. But that's an issue, is finding a vehicle for doing that. And I suggest and urge, if you're thinking about it, you got to be creative. You said the Supreme Court cases, the brain science, the brain development has something to do with that. And all those things about building relationships with the courts, with the judges and others doing it. The other thing, and I'll conclude with this because it's the most difficult part of the whole job, and that's victims, right? That as prosecutors, we have an obligation. In Maryland, it's a legal obligation, but beyond that, it's a moral and ethical obligation to talk to the victims and tell them if we're thinking of doing something different. That's true for the wrongful convictions as well as the reconsiderations. And I wish I could say that that was easy and simple. It's not. I mean, 90% of the time, the victims want the individuals to rot in hell and don't want to do it. I'm surprised when those come forward and say they believe in redemption, they believe in forgiveness, and they're willing to let it go. But it's important to do that, and you have to talk to the victims, and you have to give them the right to participate in the proceeding, to attend and give testimony, to give a victim impact statement, to do that with note. We mentioned the Saeed case. That's the issue there. It's not about, the issue right now is not about his conviction. It's about whether the victim was given the right to participate in the hearing on the sentence. And so that's the hardest part. I mean, I've been a prosecutor for, as I said, 25 years. And, it's easy when you're representing victims. And I live in a neighborhood that was, and represented in the legislature, a high crime neighborhood. So I know what people think there, and what the victims of crime think is you have to come and talk to them and explain what that is. So the discussion we had about credibility and building legitimacy is a key part of that. That's how you do that, is you go and talk to them, you tell them, you say, you may not agree, but you've got the right to do that, and we're going to help you participate in this hearing. We're going to let you speak. We're going to give you all the resources and notify you, so forth. Even if they don't agree, that's a part of the respect. That's a key part. So that's a key element, what we've been talking about here today, and so forth. So at that, I could talk a lot more, but I'll leave it there.
So my name's Mike Schmidt, and I'm in Philadelphia. And so for those of you who were hoping to see the third baseman Hall of Famer talk about resentencing today, I'm told you can get your money back. See someone for that. I'm the district attorney. I'm the elected district attorney in Multnomah County, Oregon, which is the largest county in Oregon, houses the city of Portland, but it represents the entire county. So happy to be here today. I just got to say, sitting through that last presentation of the progressive prosecutors thing, it gave me a little feeling of both being seen, so thank you, and also like I was in the zoo or something and being observed. So it was a little bit weird. But here today to talk to you about what we've done with resentencing and passing a law. And so Doyle did a good job of kind of laying out the foundations of sentencing, the reasons why. And we were able to partner with organizations, both externally and within the state of Oregon, to get our law changed to enable prosecutors to have jurisdiction to bring back cases that had previously been sentenced. And these could be cases where people are currently incarcerated, but didn't have any other kind of appeal remedies, anything like that, because it's not about the sufficiency of the conviction. Sometimes it's about whether or not we did the right things. And Doyle did a good job of talking about how things change over time. And we should be willing to adapt and be flexible in that. So we got a law passed in 2021 in Oregon. It's called SB 819, if you want to look it up. But that's our resentencing law. And it's a prosecutor-led resentencing law, where we get to work with the defense and us, the prosecution, jointly petition the court to reconsider a sentence that was imposed. And like I say, they could be for people currently serving time. They could be for people completely out of the system, people that are off probation. They have no more reason to ever come back into a courtroom at all. We can even take jurisdiction of those cases and bring those sentences back for reconsideration. So in 2021, we got the law passed. It went into effect in January 1 of 2022. So for us in Oregon, and we weren't the first state to adopt a law like this, but for us, it's been on the books for a little over around a year and a half at this point. To make that happen, we had to do a lot of things. So some of you might be thinking, like Doyle is, how do we get a law like that in our state? So what I did as a prosecutor is I brought in other prosecutors from other jurisdictions that have this law. And I purposefully tapped a prosecutor who is seen as a more, I'll call traditional, conventional, conservative, kind of more, that type of prosecutor out of Yolo County. His name's Jeff Reisig. He's done a lot of great work in this area. And then I tapped a more progressive district attorney, Dan Satterberg, who's retired now out of King County in Washington, Seattle. And I had them both come in and talk to members of the prosecuting association, the elected district attorneys. And that was really a crucial thing, because I think at first they were skeptical of changing our law to be able to resentence people. And at first, they weren't sure that that was something that they wanted to invite. But after hearing from DAs across the ideological spectrum, we got our District Attorneys Association to neutral. So they didn't get to supportive, but they did get to neutral. And that really allowed the law to pass. That allowed and opened up a lane. And then working with community advocates and like folks like Maylin helping us organize people, the combination of those things, getting prosecutors and law enforcement to neutral, having the community behind it, allowed us to successfully pass the law. So how the law works, we talked a little bit about how it can bring back cases at any posture, people in the system, people out of the system. And it's really up to the elected district attorney of the county in Oregon to decide whether they want to use it at all. There's nothing in the law that requires that it be used. If a district attorney is not interested in doing it, they don't have to. But some of us have been very active in this area. And so at least for my office, for my jurisdiction, we focused ourselves in three major buckets that we would apply this law to. One is applying it to cases where an individual claims actual innocence. Actual innocence is a very high bar, as many of you know, for folks to end up being able to prove that so that their case can be overturned. So we wanted to make this an avenue for anybody who was claiming actual innocence, but maybe couldn't meet some of those standards, that we would be willing to look at the case and reconsider whether or not we believe that the conviction, maybe it doesn't meet quite the standards that the courts require for proving actual innocence, but we thought there'd be enough there that we would say, let's resentence this individual. And when we resentence, we can bring them back and dismiss the case entirely. So that is an option for us. We look at actual innocence. We look at excessive sentences. And here we also started really kind of focusing on juveniles and people who were sentenced as young people to lengthy prison sentences. So that's another area where we said, and part of it is, you know, if you were sentenced in the 90s or the early 2000s and you got yourself a 20, 25, 30-year sentence, you know, some of those sentences are kind of out of step of what you might receive today for similar type conduct. So some of it is just saying, you know, the way that our community views this type of action and what we would impose for this is no longer the 30-year sentence that it was back then. So we're going to relook at that, especially when it involves young people, for all the reasons that were mentioned, brain science and everything else. We want to be very cognizant. Also, understanding that, you know, especially the 90s and the early thousands, but consistently throughout, but also then high focus on, you know, people, whether or not they were received fair trials. A lot of different racial dynamics at play in the criminal justice system still are today, but especially then. And so we also look at people's race and ethnicity and thinking about how we're looking at the length of the sentence that they received then and whether or not that would play into our excessive sentence calculation. And the third bucket is collateral consequences. Just recognizing that being convicted for these crimes is, it's been said already once today, the scarlet letter that will follow you around for your rest of your life. And so these could be folks who are completely out of the system. They haven't, you know, they completed their sentence, they served their time, they're off probation, they're off of post-prison supervision, parole, and they're in the community, but now they still can't get a job, they can't get housing, they can't move on with their lives. And so we consider those cases also to have them resentenced. So those are kind of the three buckets. We have our website, mcda.us. If you want to see, we have an application process on there. So you can go onto our website and download the application and then fill it out and then present that to our office for consideration. So we try to make it easily and available, and also that people can apply in one of those three areas. So that's kind of how it's working. It's been going for about a year and a half now, like we said. We do a lot of, once we receive an application, we do a lot of, it takes a lot of work on our agency's part. We reach out to the victims or remaining family members to talk to them about it. We dig into the individual who's applying. We actually verify all the things that they're telling us in terms of, you know, had they had any more criminal justice involvement, any more arrests, what was their record when they were incarcerated, when they're out. So we do a lot of that work. And then we also developed and implemented a community advisory board, a CAB. And so we have 5 individuals who sit on our CAB. One is a former judge. One is the very first person whose story I'll tell you here briefly in a second, who was the beneficiary of our 819 process. A former police officer, a victim's advocate, and a community leader, a pastor. And we have these folks. And so now when somebody fills out one of these applications, not only does our office look at it and dig into it and work with the victims, we make a write-up and a preparation. We present it to a community advisory board. And then that community advisory board ultimately will make a recommendation to me as the district attorney about whether or not I should support it. So it's a pretty robust process. But I got to tell you, the impacts have been fantastic. I mean, in terms of going out and talking to community groups. We get people all the time that are very excited about this, that have family members that are coming up to us about people who have been unable to get employed or be in housing or even go and, you know, because of their felony status. A felony conviction keeps them from going to see their kid, at high school or volunteer, or things of that nature. So it's been really well received in the community. I guess this wasn't as obvious to me, but another place that it's been really well received, and it'll be obvious when I say it out loud, but is in prison. I went and toured one of our prisons the other day, and I was there to talk about something differently, but I sat down with a group of men, this is a male prison, who are incarcerated, have been incarcerated for a long time. And they wanted to let me know the impact of this legislation and our process inside the prison. And what they told me is that it has made it safer for them, that it's changed behavior inside the prison. Because what they relayed to me is that for the first time, a lot of people had hope. They had hope that someone might actually be willing to look at their case. And what that resulted in, as they told me, and they actually, of course you get a phone call while you're speaking, is that people were signing up to take classes and to reconnect with family and make connections that they just gave up on a long time ago. And they also were looking at their behavior and making sure that, hey, if this DA is actually willing to take a look at my case, I'm not going to mess up while I'm in here. And that was resulting in a culture change within the institution. And so I was telling Maylin before I got up here, we're actually a group of those adults in custody. They produced a video for me. They had an interview and they produced a video and they sent it to my office. And it was really moving, articulating all of those things. But we're now working with a videographer who will do a professional version of that video where they can talk about the impact of their safety in the institution and how having this just available to them has created hope and change for them. So 2 quick stories about how we use this. The very first time we used this was on a man named Terence Hayes, and this is all public. It's been in the media, so I know Terence doesn't mind me sharing his story. But Terence was a young black man in Portland, and he shot another young black man in Portland, and they were both gang involved. He didn't kill him, but he was convicted of attempt murder and assault. Terence served his time. He did 13 years in prison. He got out. He did everything successfully on parole and probation. He successfully completed all that. He actually, while he was incarcerated, got some skills in terms of trades, learning how to do electrical work. And Terence wanted to use that and work and learn more and become an electrician. But of course, his conviction and his record was holding him back. And so it had been about 4 or 5 years since Terence had been completely out of our system. He had no more involvement in the criminal justice system at all. But he asked us to take a look at his case for the collateral consequences that were holding Terence and his family back from him being able to earn. We reached out to the victim's family because the victim subsequently was killed, unfortunately, but his family members remain. And so they came to the courtroom and they didn't know how they were going to feel about Terence's request to have his convictions dismissed. Terence got up in front of the judge. We presented our findings in what we thought and what our recommendation was. But Terence got up and he talked and he elocuted to the judge and said, first and foremost, how much he realized his actions had an impact not only on the young man, but his community and their family. And he gave a very heartfelt testimony and apologized. And then he talked about this conviction in his life and all those things. We took a break and my prosecutor went out, stepped out in the hallway to talk with the victim's family. And they discussed it and they sent my prosecutor back in to tell the judge that not only did they support the dismissal of all the charges against Terence, but they forgave him. And I still, every time I say it, I still get hairs on the back of my neck stand up because this created something that would not have otherwise ever happened. Terence was completely out of the system. There was no reason for him and the family members of his victims to ever interact again. They were never going to hear from Terence again. It was all done. But because of this law, because of us reconsidering Terence's conviction, we created a moment of healing, not just for Terence, but for the family members and the community members. And it has already had kind of long-reaching consequences into the community and into other family members who relayed to me of Terence's family that this was the first time that they've ever been in a courtroom and felt like it was a positive experience for the first time in their lives. So that's one way that we used it. The other way quickly is in the whole history of Multnomah County, there's a website, and I think Michigan Law School or someone keeps track of wrongful convictions. We're attributed in Multnomah County to have 9. I think we'll double that number this year. But having this legislation, so having a justice integrity unit, and I know the next panel will talk about that, to actually dig into wrongful convictions, but having this legislation has meant that when we find places where we got it wrong, we can bring that back in immediately. The prosecutor can bring it back in immediately, even if people are completely out of the system, and we can fix it right away. And it's not a perfect fix. One man, we actually got out of prison because we found out he was there wrongfully. But we were able to use this legislation, this 819, to immediately get him out of prison, get a hearing in front of the judge, and dismiss all the convictions. And for people who are out of the system, we're able to bring them back and dismiss it and not have to go through any kind of other, how are we going to figure this out? Doyle talked about, before this legislation, you kind of needed a judge who was, I like how you said it, open-minded. A judge who you could kind of go and be like, Judge, we don't really have jurisdiction to be here, but it's kind of the right thing to do. Would you mind dismissing this charge? And everyone hopes that there's not a reporter in the courtroom. And you do the right thing. Because we have this legislation and this statutory authority, we don't have to rely on that anymore. We have jurisdiction and we can do the right thing. Thank you.
I wanted to aim at me here, but specifically, but have I ever used a colorable constitutional or state law claim as the issue raised by the defense and agreed to reverse a conviction and accept a pre-agreed plea bargain for another offense? And the answer is yes. Much like Mike mentioned, some of the cases we deal with there were post-conviction issues, usually not wrongful convictions, but an incompetent attorney, something else, that could be fought and litigated, and there were probably arguments why they would not work. There's cases that sort of say you can only have a post-conviction claim once and you have to raise it. But we would agree, and we would then consent, to the post-conviction with the understanding that there would be a reconsideration and a new sentence. So that is one of the things we do. On the sentence side, we're not overturning convictions by and large. I appreciate what Mike has mentioned, being able to do that. And there are cases where that is, but we are changing the sentence, and mostly that means letting people out. The other one that had my name on it I'll do is tell us about a time when a victim opposed release, but you favored it, and what went ahead with a reduction. Well, that happens all the time. I'm sorry, I hate to say it, that in the vast majority of cases, and I have one that I had on Monday, I had a call with the family, the next of kin of the victims in a murder, where somebody that we are supporting a reconsideration of the sentence and basically putting him into a treatment rehab reentry program. I understand where they're at. And if I was in their shoes and it was my family member that was killed, I might feel the same. But our obligation is really still to do justice and to take into account the bigger picture. So yes, that happens. It's the exception when, and I've had that example where Mike mentioned that family came in, was opposed, listened to the case that was presented by the defense attorneys, and that's one of the questions. We work very closely with defense attorneys on this, and we almost always want there to be a defense attorney because the individual involved has rights that they're in effect endangering and giving up by participating in this process. But they presented the case, we agreed, and the family, there was a break for lunch, and they went out and they actually met some of the other family members that were there in support of the person, and came back and said, well, we met them. They're wonderful and they're great. They're a great support network. we're okay. Go ahead. Well, that made it easy for the judge when that happens, but the other ones are not so easy.
All right, you took the defense attorney one. This question says, seems like a successful system. What are the downsides or the areas for improvement? I think one of the areas for improvement or things that I would advocate for is more resources. We have in our justice integrity unit, we have 3 attorneys, which is a significant contribution for me, for our office, using attorneys in this way. But they do a lot of work. They do expungements. They work with the governor's office on clemencies and pardons. Oregon has the dubious distinction of being one of the last 2 states to have non-unanimous juries. That has finally come home to roost because, of course, now we don't. We have unanimous juries after the Supreme Court decisions. But all those cases are coming back. So we're re-looking and re-examining those. So my small justice integrity unit does a lot of work, and this is just part of it. I wish we could do a lot more. The number of applications that we have far outstrip our ability to keep up with it. And so that also can be frustrating for folks. So on the one hand, it is great because it creates hope. But on the other hand, if it takes us a year or 2 years to get to their cases, that can also kind of erode some of that trust in that. So there's the staffing it adequately. Any state that is considering making laws like this, I highly recommend having it come with some resources. And the same goes on the victim side. We have victim advocates in our office, and so they are integral to our ability to reach out to them, to have trauma-informed conversations, to get them to the place. Because, as was mentioned, frequently, when you first get cold called and said, hey, what do you think about so-and-so getting out of prison? Well, you can imagine what the answer to that is most of the time. But if people think about it for a little while in terms from the victim's perspective, they think about it and sit with it. I frequently see people say, well, maybe I just need to learn more. Tell me more about it and change. But having victim advocates to be there and help them understand the procedure and the process is crucial to them also being okay with this process. So I think the biggest downsides for me is resources, having the resources to do it.
And one of the criticisms that's raised by some of our state's attorney colleagues is the re-victimization of the victims and then families of the victims. And that's clearly a downside. I mean, they'll get up here and we have a state's attorney that gets up and recites every single conceivable thing that they could do and say they have to come 14 different times and there were 4 defendants and now there's 14 times 4 and so forth. So that is a very real concern, not quite that extreme in practice because that's really not how the system works, but it does put a real burden on victims. And one of the questions from somebody who, either assisted or was commuted after a long sentence is that the family of the victims came and talked, and should they, in effect, have been allowed to do that? And the answer is yes, as far as we're concerned, that crime, particularly serious, murders, rapes, violent crime, totally undermines and destroys families.
That was a great example. That was 3-4 generations later.
Well, and
that was he had drove the getaway car. They get him out, but that's the first time I seen that long in generations where they able to get the victim impact statement.
Well, and obviously judges, that's what judges are there to sort of balance out some of that. But we don't want to, from our point of view at least, and I think the state's attorney that I serve feels strongly about that, we are not going to make those arbitrary distinctions. We're not going to make decisions. We'll make our recommendations. We'll state our reasons. And the judges who do the sentencing all the time, and they have to balance these things, can sort out what's going on. To try to do otherwise creates controversy and conflict, and that is a downside. It's the fear on this, and the fear of judges is the political fear. One of the reasons we support the prosecutor-initiated reconsideration as opposed to just reconsideration. We had that proposal in Maryland that went through the Rules Committee and to our Supreme Court and they didn't do it was they were afraid there would be a deluge of cases, so that this puts the state prosecutors, for rightly or wrongly, in the position of screening the case and limiting the impact on the judicial system for reopening cases with all the problems that that kind of creates.
So I have a question that says, as to the effects of resentencing laws on the behavior of those who are incarcerated, are there any fears that they might be feigning good behavior to game the system? If so, what do we do to guard against it? I love this question because on the one hand, I don't care if they're pretending to be good, but in pretending to be good or actually being good, then I'm okay with that. If they're signing up for classes and engaging with community outside the walls and they're not getting into fights, but they're just doing it to fool me, like, keep at it, keep it up. But on the other hand, I also get the point of the question, which is, that there are, how do you distinguish people who, I think what we're looking for is people who do we see evidence of change? Do we see evidence that when this person comes back into our community, that they're going to be safe? I mean, my job is around public safety. And so I certainly don't want to be, getting folks out of incarceration and then back into a situation where they're, continuing to act in a way that would victimize other people. So I do care about it in that sense. We do a very kind of deep background, exhaustive process with the Department of Corrections. Can we be fooled? Yeah. I mean, if somebody is, has good behavior for 5-10 years with no write-ups and anything else, they're doing all the right things. It's possible to get fooled for sure. But we also do something I think Doyle talked about, which is we look at the reentry plan as well. What is the plan for you coming out? What are the things that wrap around you? How are you going to be connected to those things to make sure that the behavior is continually, that you are successful and that we're supporting that success?
And sort of a final comment, I guess, and we have experience in Maryland because we had a case in our Supreme Court that overturned hundreds of murder convictions. And a lot of those people were released many times after long sentences. And the recidivism rate is very tiny. And, there is, with the exception maybe of sex crimes and maybe theft, I don't know, people age out of crime, right? Because it's about impulse control and knowledge and experience and maturity. So that certainly is a factor that illuminates some of our thinking about that's relevant for those who've been in for a long period of time. Maybe not those for a short period of time.
So I'll just, I think we're at our time, but I'll just wrap by saying, I reached out to other district attorneys to come in and advocate to my district attorney association. If I can help anybody else, I'm happy to do that, to be a resource to
Can we book you to Maryland?
Absolutely. Absolutely. Happy to, because it really helped. It helped us in Oregon to get this passed. And it really has been a big deal for us. Thank you.
Thank you.